Hi, Attorney Steve Vaughn, and we're back, licensed to practice law, California and Arizona. We are talking today real estate law. We are talking commission, college. We are talking brokers defending their turf. Every now and then it happens that a broker in a certain area becomes very successful and other brokers are upset, and this broker's getting all the big deals, this broker's owning the turf, this broker is the go-to guy or gal in that area, and everybody else wants to just go after that broker and tarnish them and say this guy's no good, she's no good, shouldn't be using this person, that kind of thing. Every now and then we get calls where a broker says, look, I need to defend my name, I need to defend my turf, people are using my name, my image, they're using copyrighted photos of me without my consent, they're writing trash about me on the internet, they're posting disparaging remarks on Facebook, they're talking about me on their YouTube channels, or they're tweeting about me in what we call a mean tweet, those kinds of things. So there are some rights that you have, and it's very important to understand sort of the general lay of the land when it comes to digital media and even offline media. Sometimes the disparagement we've seen take place in offline forms, such as newspapers, where somebody may be taking out an ad with your name, image, likeness, talking about you, this, that, or the other. So it's real important to understand kind of the First Amendment versus intellectual property rights and the intersection of fair business practices versus unfair business practices, things that may cross the line and force you to send a cease and desist letter to your adversaries or to possibly file a legal lawsuit. Okay, so let's go to the Attorney Steve Real Estate whiteboard. All right, we're back. This is called Defend Your Turf. Okay, so we're talking about basically defending your turf, making sure that your good name and reputation and that your commercial image is protected by you, controlled by you. Okay, let's go down the list. This is our short checklist of some potential things that can arise when you're a real estate broker doing business on your turf. Some things that can arise. Let's start with defamation. Okay, everybody always talks about defamation. You know, this person is slandering me. This person is committing acts of libel. They're abusing my name. They're saying I'm the worst realtor in town. They're saying I'm a scam artist. They're posting up on Yelp that I'm a rip-off artist, that I'm the worst. They're posting false complaints about me. All sorts of things can happen in what I call the digital jungle, where people are out just trying to climb up the mountaintop. Okay, it's very simple. It's king of the mountain. You have somebody that's up here that's worked hard to get their good name up there, and other people that are trying to tear them down and bite into the market share. So defamation has two forms. You have libel and you have slander. Okay, what's the difference? Libel is written defamation. How I remembered it in law school was label. Like a label is something in writing, you put it on a thing. So label, libel, written defamation is libel. That's actionable. The other form of defamation is slander. Slander is one person to another person. Basically that publication. When you have defamation, you need a publication. So the false statement needs to be made and published to other parties, one or more parties, okay? And that statement has to be false, and it has to cause damage. If it's somebody's opinion and they're just saying, in my opinion, the broker cuts corners. That's more of an opinion, probably not something that's going to be actionable. But if you say something like, that broker, I heard that they run a property management company and they stole $100,000. That's not an opinion, that's really more of a statement of fact, things that you can say, wait a second, that's a false statement of fact, made about me, publicated to a third party, not true, not protected First Amendment opinion. Remember, First Amendment, we have that, protected opinions, free speech, and that has caused me damages. If you can meet those elements, if you can prove it's not true, if you can prove you were damaged, then you may have a cause of action for defamation. Now you have to keep in mind with defamation is that people do have the right to First Amendment free speech. If you're out filing defamation claims and there is some protected free speech issues, you could have what's called an anti-slap motion filed, basically saying that you're curbing their right for free speech, this and that, and then somebody could come seek attorney fees from you. So you want to be really careful and have a internet defamation attorney review your case and see what you have. But this is one of the big ones, defamation. This pops up with a lot of social media websites where people are talking about being defamed online, companies being defamed, those kinds of things. Similar to this is false light. Now, false light is basically a publication that's like essentially true, it's essentially factual, but it's created in a way that it's putting somebody in a false light. It's hard to come up with an example in the real estate context, but maybe saying, somebody's retiring or is retired and they're actually not retired yet, something like that, where it's like sort of technically true, but you're placing them in a false light. Again, if it's objectionable to a reasonable person, causing damages, you may have a false light type of argument. Now keep in mind, whenever you're dealing with a media defendant, when we're talking like media type defendants, newspapers, bloggers, podcasters, general circulation newspapers, the media, okay, what we perceive to be as the media, and that may be another issue. Usually you have a higher standard. It's called the New York Times. It's called the New York Times standard, and you can look that up if you like. New York Times v. Sullivan, a case that talks about you need to show that the false statement is reckless, in reckless disregard of the truth, or intentionally false, those kinds of things. So it's a higher standard when you have a media defendant at issue, because we want to be able to report the press and give some little leeway for things that aren't maybe not be 100% accurate. Okay, so that's that. Publication of private facts. This would be something that's highly offensive to a reasonable person. Basically, it would be something that's probably true, but publicizing something that, let's say, for example, realtor Joe the broker has herpes. Okay, that may be true. It may be true, but it doesn't really have any legitimate market value to it. Obviously, there's just some intent to injure and harm a person. That's when you may be looking at publication of private facts that have no reasonable media component to it, no reasonable media component, and something that would be highly objectionable to a reasonable person. So that can be, again, these are torts. These are torts, the different tort actions that you look at. Intrusion on seclusion and solitude. Here's another one. Posting pictures of, say, here's a broker having sex with another person in Hawaii or something, and you're taking that photo, you're intruding on someone's seclusion and solitude, and then you're posting it on the internet, while may be true, right? And for the brokers, probably happy that it is true. You have potential problems with intrusion on seclusion and solitude, which is a privacy tort, or publication of private facts kind of thing. So this gives you an idea. Another cause of action that pops up, intentional infliction of emotional distress. If you can prove the posting was intentional, reckless, extreme and outrageous conduct, and that it causes severe mental or emotional distress, you can potentially have a cause of action for intentional infliction of emotional distress. Okay, those usually require some doctor bills, medical bills, verifying that there really was some mental distress. We have two other issues. Copyright, that's when somebody's using your image, a picture, poster, things that you've created, your logos, slogans, without your consent. That's a copyright issue. Potentially you can recover attorney fees and damages. If you have willful infringement, there may be some increased damages that you can recover. So copyright, that's usually your federal causes of action. Copyright is an issue that pops up in real estate from time to time. Finally, right of publicity for California brokers. This is embodied in the Civil Code. It's in the common law. Every broker, every realtor has the right to control their name, image, and likeness, and even nicknames can be covered under that. So it's really important if somebody's using that, your name, image, likeness without consent, then you might have a cause of action under California's right of publicity statutes. So these are some of the main things that pop up when we're dealing with brokers and real estate agents and others, company owners, business owners that are dealing with defamation, basically things that are going beyond the lines of fair decency and crossing into tortious activity. So if you need some help defending your turf, civil litigation, arbitration, business and real estate law, give us a call. Attorney Steve Vondran. You can find out more at askattorneysteve.com.